Gary DeWaal here, and this is Bridging the Week for September 29th to October 3rd, and today is October 6, 2014. Good morning. Last week, market disruption activities were the focus of a surprising criminal indictment and the settlement of a complaint charging attempted manipulation brought by the Commodity Futures Trading Commission. In fact, the CFTC was involved in a host of litigation developments, including one involving an enforcement action against the New York Mercantile Exchange related to the alleged disclosure of non-public customer and trade data by two of the exchange's ex-employees. We have a lot on the agenda this week, so let's get started. Last week, New Jersey resident Michael Casilla, the prior manager and sole owner of Panther Energy Trading LLC, was indicted in Chicago, Illinois, related to alleged spoofing activities involving futures traded on CME Group and ICE Futures Europe from August through October 2011. Previously, in July 2013, the Commodity Futures Trading Commission, the UK Financial Conduct Authority, and the CME brought enforcement proceedings and entered in simultaneous settlements with Mr. Casilla and Panther related to the same conduct, assessing aggregate sanctions in excess of approximately $3 million and various trading prohibition. The CME also required disgorgement of $1.3 million of trading profits. According to the new indictment, during the relevant time, Mr. Casilla utilized two computer-driven algorithmic trading programs that repeatedly placed small buy-or-sell orders in a market, followed by the rapid placement and retraction of large orders, so-called quote orders, on the opposite side of the small orders. He supposedly did this in order to deceive the market and help ensure the execution of his small orders at favorable prices. After the initial small orders were executed, Mr. Casilla would reverse the process, placing new small orders on the opposite side of the market as his initial filled orders, and large quote orders on the opposite side of his new small orders. Allegedly, he traded this way in order to assure the fills of his new small orders and profits on the overall transaction. The indictment alleges that in connection with his unlawful activity, Mr. Casilla traded over 17 different CME markets and 3 different ICE Futures Europe markets, including gold, foreign exchange, and soybean oil future contracts. Mr. Casilla made over $1.5 million as a result of his trading activity, claims the indictment. Mr. Casilla's indictment alleges 6 counts of commodities fraud and 6 counts of spoofing that relate solely, however, to 6 discrete trading episodes, which in total allegedly netted Mr. Casilla $1,070 in profits. Huh? How do we go from over $1 million in overall problem to $1,000? Spoofing was expressly prohibited in 2010 by amendments to relevant law enacted as part of the Dodd-Frank reforms. This is the first case brought by the U.S. Attorney's Office in Chicago under the new law. You will recall recently the CME also enacted a new rule expressly prohibiting certain disruptive trading practices. Check out the article on this website on September 4th regarding this. Mr. Casilla faces substantial prison fines and fines if convicted, 25 years for each count of commodities fraud, and 10 years for each count of spoofing. Geez, when is enough enough? The CFTC obtained a consent order against Eric Moncada in connection with its allegation that Mr. Moncada attempted to manipulate the December 2009 wheat futures contract traded on the Chicago Board of Trade on 8 days during October 2009. According to the CFTC, on these days, Mr. Moncada manually placed and immediately canceled numerous orders for 200 lots or more of the relevant futures contract, or placed large lot orders near the best bidder offer in a manner to avoid execution. The CFTC claimed that Mr. Moncada also placed small lot orders on the opposite side of the market, quote, with the intent of taking advantage of any price movement that might result from the misleading impression of increasing liquidity that his large lot orders created, end of quote. To resolve this matter, Mr. Moncada agreed to pay a fine of US $1.56 million, refrain from trading any CFTC-regulated wheat futures or options for 5 years, and trading any product on a designated contract market or swap execution facility for 1 year, among other sanctions. This case was brought on facts that occurred prior to the adoption of the Dodd-Frank Act's market disruption prohibition, and provides a good example that the prosecution of market disruption cases is nothing new for the CFTC or exchanges. This case also demonstrates that it is a misnomer to believe that market disruption may only be caused by so-called high-frequency traders. If this case had been based on more current facts, it is likely that Mr. Moncada would have been charged with spoofing. The Securities and Exchange Commission brought an administrative action against Bank of America Corporation for misstating the amount of its regulatory capital and ratios in numerous financial reports filed with the SEC from 2009 to 2013. Bank of America was required to file such reports with the SEC as a public company. This error apparently arose in connection with Bank of America's acquisition of Merrill Lynch & Co. at the beginning of 2009 and related to the way Bank of America recorded on its books and records and later redeemed Merrill Lynch-issued securities. According to the SEC, Bank of America self-detected its mistake during April 2014, issued a press release revising its regulatory capital amounts and ratios, and filed an amendment with the SEC correcting its most recently filed financial report. Bank of America agreed to pay a fine of $7.65 million to resolve this matter. A federal district court in the District of Columbia rejected challenges by the New York State and Tennessee Republican parties to a regulation of the Securities and Exchange Commission that prohibits registered investment advisors from providing advisory services for compensation to a government entity within 2 years after making a contribution to certain officials of that entity. This prohibition against so-called quote-unquote pay-to-play arrangements was enacted in 2010. However, before you get out your checks, the basis for the court's rejection of plaintiff's suit was technical. The court wrote that it lacked subject matter jurisdiction over plaintiff's action, claiming that the challenge under applicable law should have been brought in the Court of Appeals for the District of Columbia, not the District Court. And finally, a New York City-based federal court rejected a challenge by the New York Mercantile Exchange that the Commodity Futures Trading Commission could not sue NYMEX for violations by its employees of a statutory prohibition against disclosing non-public information, quote-unquote, inconsistent with the performance of such person's official duties as an employee or member of a registered entity such as NYMEX. NYMEX is a designated contract market under law. In 2013, the CFTC had sued William Burns and Christopher Curtin, two former NYMEX employees, for improperly disclosing non-public trading customer data they learned through their jobs to a third party, Ron Eibschutz, in return for meals, drinks, and entertainment at multiple times. The CFTC also named NYMEX in the suit, claiming it was liable for all violations of Messrs. Burns and Curtin as their employer under a legal theory known as respondeat superior. NYMEX had argued that it could not be liable for Messrs. Burns and Curtin's actions because the relevant law only permits attribution of employee actions to NYMEX, not liability. In any case, argued NYMEX, it can only be disciplined for potentially violating quote-unquote core principles to which it is subject under law as a designated contract market. The court rejected both arguments. The court also held that the CFTC had alleged sufficient facts to defeat NYMEX's efforts to dismiss the Commission's lawsuit against the exchange. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Until next week, this is Gary DeWaal. Have a great week, and ciao!